You know, when a judge finally signs that child custody order, it can feel like this massive, final thing. But life happens, right? It doesn't just freeze in place. People change jobs, they move, and what was best for your kid a year ago, it might not be what's best for them today.
So that leads to the big question, right? If your life has changed, can your custody order actually change along with it? And the answer is yes. But, and this is a huge but, the legal path to making that happen is, well, it's incredibly tough.
And honestly, this is where a lot of people get tripped up. See, getting custody for the very first time is a whole different ballgame than trying to change an order that's already on the books. The court sets the bar way, way higher the second time around. Why? Because their main focus shifts to one thing above all else: stability for the child.
So you've really got two totally different worlds in custody law. For that initial custody decision, the court is asking a pretty broad question. What's in the best interest of this child? Simple enough. But the moment that order is signed, the game completely changes. If you want to modify that order, you, the parent asking for the change, have to meet this really strict legal test. And in Alabama, that's called the McClendon standard.
So where does this come from? Well, it's named after a big Alabama Supreme Court case from back in 1984, Ex parte McClendon. And what it does is it sets up this really demanding two-part test, a burden of proof that the parent has to meet. It's not enough to just walk in and say, hey, this change would be good. You have to prove that it's absolutely necessary for the child.
But why? Why is the bar set so incredibly high? It really gets to the core of how the court thinks. The whole point of the McClendon standard is to shield the child from what the court calls the inherently disruptive effect of being uprooted. The court's starting point, its default position, is that stability is everything. And if you want to change that, you're the one who has to overcome that massive presumption. Okay, so the test has two parts, and here's the kicker. You have to prove both. You can't just do one. First, you have to show that there's been a substantial change in circumstances since that last order was made. And second, you have to prove that changing custody would materially promote your child's best interests. And this is key, that this benefit is so big it actually outweighs the disruption of making the change. It's a 1-2 punch, and you have to land both.
All right, so that's the legal theory. But what does this look like in the real world? You know, in an actual courtroom. Let's dive into some real cases from Alabama, so you can see what kind of stuff actually manages to clear this super high bar.
Okay, look at this. The details are everything. In one case, ex parte Roberts, a mom moving away for college was enough to change custody. But then you have Cox v. Ratcliffe, where a dad's move wasn't enough, especially since he hadn't had much contact before. See the difference? Or look at this. In England v. England, the court changed custody because the mom was actively, purposefully messing with the dad's visits. But in another case, ex parte Pappers, some minor visitation issues? Nope, not enough to uproot the kid. It's all about the degree of the problem. And this pattern gets even clearer when you look at a parent's behavior. For example, in SF v. BLT, solid evidence of drug selling, that was enough for a change. But then in the Hanners case, a father's drug use, even with arrests, wasn't. So what's the difference? It all comes down to the direct negative impact on the child. So in Callaway, clear neglect, like really poor hygiene, that was enough. But in Taylor, what the court called a parent's indiscreet conduct, well, if you couldn't prove it was actually harming the child, it wasn't enough to change custody.
So when a judge is looking at all this, they're weighing a ton of factors. They're comparing the stability of both homes, if a child's school or daycare would have to change, any new partners in the picture, and how well the parents are even getting along. But the real takeaway, the thing you have to remember, is that last point. A parent's personal life or their conduct, even if you find it totally questionable, it's legally irrelevant unless you can draw a straight line from that behavior to a direct, harmful effect on the child.
And that just brings us right back around to the core principle, the absolute heart of the McClendon standard. I'm going to say it again because it's that important. The positive things that would come from changing custody, they have to be so big, so beneficial, that they outweigh the disruption that is guaranteed to happen when you pull a kid out of the life they know. So, to wrap this all up, the question you really need to ask yourself isn't just, hey, is my life different now? The real question is this. Is this change so powerfully, so materially beneficial to my child that it justifies tearing down the stable world the court has already tried to build for them? because at the end of the day, that's the only question the court is going to be asking.